Dispute Resolution Board (DRB). DRB is a board of individuals that resolve dispute on construction project. Usually, the contract will provide for 3 members, which 2 technical and 1 legal. These regulations allow the technical dispute to fully understood and resolved without the need of external advice, and similarly, dispute involving or including legal issues become capable for resolution without external advice. Once the member of the DRB has been appointed, the procedure should allow the regular visit to site, including time to deal with any differences that have arisen. The formal dispute provider usually involves the dissatisfied party issue a written notice containing detail of dispute to the other party and to the DRB. That timing of notice may be depends on the type of contract. For example, FedEx only allows 28 days after engineering decision in which to issue a notice. When having issued the notice, the claimant has to prepare a position statement in which they set out their legal and factual arguments supported by evidence. On receipt, the defendants will prepare their position statement responding to the claimant's narrative, setting out their arguments and the evidence relies upon. Having received the 2 position statements, the DRB will consider the matter rises. If necessary, the member of the DRB will meet before hearing to discuss procedural or substantive matter. The DRB will prepare a list of questions of future document required so that the hearing will be able to deal fully with all matters arising. The hearing will normally be held within 13 days of the event begins server, usually near the project. The length of hearing is depends on the complexity of the matter. Mostly hearing will not exceed 2 or 3 days. The hearing follows the usual course: a submission by the claimant, a submission by way of reply for the defendant, with perhaps question and point of clarification raised by the DRB. If necessary, the engineer will be allowed to make submission or answer questions. After hearing is brought to a close, the DRB will continue with its deliberations and the draft reclamation or adjudication decision will be prepared. This is necessary as 3 members will return home to prepare their individual report for later discussion and to finalize their recommendation and adjudication decision. The declarations of decision will be produced by way of a writing report. When board provide recommendation, this can be without extension of time limit. To provide certainty, a time limit can be prescribed for any written objection to be met by either party. If not objection is arised, then the recommendation can become binding on the party. In any event, the recommendation of decision should be set in the contract to be acted upon immediately in its provisions.
Case study.
In 2007, the plaintiff, Sbeq Resort, who is the project owner for the construction of a 45-story hotel and condominium building at New York, and the defendant, Payarini, entered into a contract under which Payarini agreed to provide construction management service for the project. The Sbeq entered into a construction management agreement (CMA), which Payarini agreed to act as general contractor to construct a hotel and condominium building and responsible for managing and hiring subcontractor. The CMA provided that Payarini could receive progress payment to a requisition procedure based on the project performed by its subcontractor. If Sbeq disputed the work, it nonetheless had to pay the requisitions and thereafter submit the dispute to Dispute Review Board, the specialized ADR forum selected by the parties in CMA. The pay-first principle also applied to the DRB resolution. The written resolutions of the DRB was binding upon the parties for the duration of project through completion and final payment. It precluded the parties from suing each other. Pursuant to CMA, after the final payment and the expiration of a 60 days cooling off period, either party could challenge the DRB resolution through litigation. Between 2009 and 2013, the DRB rendered roughly 50 resolutions and supplemental resolutions and over 200 partial resolutions. DRB's final accounting resolution awarded Payarini over 8 million as final payment. Waterscape discharged Payarini as construction manager and proposed to terminate CMA in September 2010. When project was nearly completed, Payarini contended that Waterscape had wrongly withheld progress payment on Payarini over 10 million and the party engaged in dispute resolution before the DRB. The proposed terminations did not affect the jurisdiction of the DRB, which continued until final payment was met. This is because, due to the CMA Article 18, the DRB shall continue in existence for the durations of the construction of project and through final payment. Waterscape made the final payment to Payarini on 2014 and its litigation was committed approximately 1 year later. In the complaint, Waterscape disputed the amounts the DRB determined to put on to Payarini. This action has an protracted litigation history, including persisting claims in the United States Bankruptcy Court.
The discussion of the case studies. Waterscape contends that no court has ever decided the validity of the DBR final resolution and argues that litigation at trial is its contractual right. Here, 3 separate courts have ruled that the DRB provision in the CMA are ambiguous and not a model for clarity. Noting that the provision relating to the binding nature of the DRB resolution has been found to be ambiguous upon judicial review. Indeed, Justice Brown found the CMA provision to be ambiguous and held that there has to be a trial to determine what those ambiguous provisions mean. Waterscape's dismay with the SMA pay first principle is understandable. It contends that the DRB got it wrong and fear that if it successfully challenges the DRB solution, it will have to chase Pavarini for a refund of the final payment. Nevertheless, this is the bargain the parties made, and the court duty is to enforce it according to its terms. In conclusion, the use of dispute review boards (DRB) and evolution of the natural expert determination process is currently one of the much sought after mechanism. In contrast to the traditional method of resolving construction dispute, DRB seeks to avoid or minimize the incidence of dispute by a timely and relatively informal process which takes place while the work is in progress. DRB assists in the resolution of dispute for the duration of the project. The contractual clause creating a DRB needs to specify precisely how it is constituted and how it operates, including all necessary administrative arrangements. Usually, the determination of DRB are to be simply advisory, which is non-binding. The determination only becomes binding when it's overturned by arbitration or litigation, or fully and immediately binding as an exclusive unappealable remedy. The current preference is to use DRB process as a first step to resolving a dispute where arbitration may be made available for the parties to finally resolve the dispute. In our case study, the decision of DRB is binding upon the completion of project, and the decision only can be challenged after the completion of the project pursuant to the Construction Management Agreement (CMA) between Waterscape Resort and Pavarini. The courts have ruled that the DRB provision in the CMA are ambiguous, but it is undeniable that compared to the traditional method, the DRB has avoided and minimized the incidence of dispute by timely and relatively informal resolution process which take place while the work is in progress. DRB provides good dispute control in order to avoid wasting time for the court to determine the dispute resolution during the construction stage, because the parties will be continuing with the works. So that's all. Thank you.